Welcome to The Explainer. Today, we're diving into a really critical step in the justice system, the world of criminal appeals in the Philippines. We're going to break down what can be a pretty complex legal process into something that hopefully makes a lot more sense. So picture this. A verdict just came down in a criminal trial. You might think, okay, that's it, case closed. But for a lot of people, that's not the end of the road at all. It's actually the start of a brand new chapter, the appeal. So that brings us to our first section. What happens right after the verdict? We're talking about the appeal itself. So what is it exactly, and how does it work? At its core, an appeal is basically asking a higher court to take a second look. It's like saying, hey, we think the first court might have gotten something wrong. Can you please review it? And this isn't just some minor detail. It's a really fundamental part of the justice system. It acts as a crucial safety net, a check and balance to make sure everything was done by the book. Okay, so who actually gets to ask for this second look? It's not a free-for-all. And when we dig into who can and can't appeal, you start to see a really interesting and pretty significant difference between the key players. Okay, take a look at this, because this is where it gets really interesting. On one side, you've got the accused. If they're convicted, they can pretty much appeal that judgment, no problem. But then look at the prosecution side. It's a whole different story. They can appeal certain things, but when it comes to a judgment of acquittal, they run smack into this massive legal wall called double jeopardy. And we're going to talk more about that in a bit. But just know, it's a huge deal and it severely ties their hands. And we can't forget about the victim, or what the law calls the offended party. They have a say too, but it's very specific. They can't appeal the not guilty verdict itself, but they can appeal the civil part of the judgment. Things like the amount of money awarded for damages. And what's interesting is they can go ahead and do this all on their own, even if the state decides not to get involved. All right, so let's say someone decides they want to appeal. Well, they better act fast, because they're immediately up against the clock. This brings us to the 15-day countdown. And when we say the clock is ticking, we mean it. You have exactly 15 days. That's it. From the second the judgment is officially received, that countdown starts. And it is absolutely unforgiving. If you miss that deadline, even by an hour, the chance to appeal is gone. Poof, forever. So what do you have to do in those 15 days? Well, the first couple of steps are actually pretty straightforward, but they are absolutely critical. First, you file something called a notice of appeal, and you file it with the very same court that handed down the decision. Then it's the court's job to bundle up all the original records of the case and send the whole package up to the higher appellate court. Now, is there any way to hit the pause button on this 15-day countdown? Yes, there is one. You can file what's called a motion for a new trial or a motion for reconsideration. Doing that suspends the clock. But, and this is a big but, the moment that motion gets denied, the clock starts ticking again right from where you left off. So if you had 10 days left, you still only have 10 days left. Okay, we've mentioned it already, but now we need to talk about the single most important rule that hangs over this entire process. It's a constitutional shield, really, and it's called the double jeopardy rule. So what is double jeopardy? Well, it's a massive constitutional protection. At its heart, it says the government only gets one shot to convict you for a crime. If you're acquitted, meaning found not guilty, that's it. They can't just keep dragging you back into court over and over for the same thing, hoping for a different result. And that principle leads directly to this quote. Generally, no appeal is allowed from a judgment of acquittal on the merits. This really shows you how powerful the rule is. When a court looks at all the evidence and says not guilty, that is, for the most part, the final word for the prosecution. Now, I did say for the most part, because like with many legal rules, there are some super rare exceptions. We're talking about really specific situations. For example, maybe the trial court didn't even have the legal authority, the jurisdiction to hear the case in the first place. Or in some extreme cases, if the trial had such serious mistakes that it wasn't even a real trial. But again, these are very, very narrow exceptions. Okay, so the appeal has been filed, it's been accepted. Now what? What actually happens up at that higher court? This is a really important idea to grasp. When the accused files an appeal, the case is, as they say, thrown open. It means the higher court isn't just looking at the one or two things the appeal lawyer complained about. Nope. They can look at the entire case, from start to finish. Everything is back on the table for review. The good, the bad, and the ugly for the accused. So after this deep dive into the whole case, the appellate court has a lot of power. They can come to a few different conclusions. First, they can affirm the decision, which basically means they agree with the lower court and everything stays the same. Second, they can modify it. Maybe they agree with the conviction but think the penalty was too harsh, so they change it. Or third, they can reverse the decision completely, which could mean a conviction gets overturned. That whole thrown open thing, it naturally leads to a really scary question, right? If you're the one appealing and the entire case is being looked at again, is there a chance the penalty could actually get worse? And the answer, generally, is no. Whew, double jeopardy steps in again as a shield. As long as it's only the accused who appealed, the higher court can't make the punishment more severe. You can't be put in a worse position just for exercising your right to an appeal. Now, the only time that could change is if the prosecution also filed their own valid appeal. But, as we've seen, that's pretty rare.
So, when you put all these pieces together, the strict deadlines, the huge power of double jeopardy, who can appeal and what can happen, you start to see this really intricate dance. It's a system of checks and balances, all aimed at finding fairness. Which leaves us with this final question to think about. Does the appeal process truly offer a second chance at justice, or is it just another layer of procedure? It really makes you think about how the system tries to balance getting things right with the need for a final decision.